Welcome to the deep dive, where we take complex stuff and try to make it clear, concise, and actually pretty interesting. Today, we're plunging into a real high-stakes legal drama. Think of it like a chess match playing out in real time in the New York Supreme Court.
hmm
And this is about a civil case, Chantel McLaurin v. Andrew Walcott. We're looking at some really audacious moves the defendant tried to pull, like, right before a major trial.
Literally days before, yeah.
So our mission today, it's really to understand these bold tactics, how the plaintiff's lawyers and the court push back, and what it tells us about, the difference between just accusing someone and having real evidence.
That's exactly it. It's like imagine you're right at the finish line, what lawyers sometimes call the 0 hour, the eve of trial, and one side suddenly tries to, slip the whole board over.
Right.
In this case, the defendant, Walcott, filed two big last-minute motions. And these weren't just minor tweaks, they were really aggressive plays, clearly aimed at stopping the plaintiff from even getting to trial.
Okay, so let's get into the first one. This sounds like the most dramatic move trying to disqualify the plaintiff's own lawyers, the firm SU Bine LLP.
Yeah.
That's a huge step, especially so close to the trial date.
It really is.
So, just to be clear, the defense was basically saying, hey, your lawyers are accused of something bad in a totally different case, so they can't represent you here. It sounds a bit like guilt by association, doesn't it?
It does, yeah. And that's exactly why it gave such strong pushback. The defendant's main argument was that Essubine LLP, and kind of by extension, the plaintiff Chantel McLaurin, were named in this separate civil RICO complaint.
RICO, that sounds serious. Racketeer-influenced and corrupt organizations.
Exactly. Now, a civil RICO complaint, just for context, it's often used in federal court against organized crime, but private parties can also use it to sue over things like alleged fraud patterns. This one was filed by some insurance companies alleging purported fraudulent schemes.
Okay, so the defendant latches onto that separate RICO case and argues it creates an unwaivable conflict of interest for the lawyers in this case.
Right.
Their claim was basically the firm's judgment would be clouded because they'd be worried about their own skin in the RFO case. And get this, they even suggested that going forward with this trial would somehow create further evidence against the law firm for the RFO thing.
Which is quite a claim.
And then, the cherry on top, they demanded this detailed allocution, like a formal court statement, from the plaintiff herself, making her explicitly waive this supposed conflict. It feels like they were trying to force her to admit a conflict that wasn't really there.
Absolutely. And this is where the key legal point comes in, the one that really underpins everything. It's the fundamental difference between an allegation and actual evidence.
Okay.
A civil or theo complaint, like the one here, is really just a container for allegations. It's a formal accusation, yes, but it's not proven fact. It's not evidence you can just bring into another trial.
So it's just a claim someone else made.
Precisely. And the plaintiff's counsel hammered this point home. They quoted directly from another case, Castillo v. 1248 Associates LLC. The court there said, and this is key, the civil IKO complaint does not constitute new facts or evidence, as that complaint is merely sick of the vehicle for allegations.
Got it. So that Castillo quote is basically the foundation for saying, nice try, but these are just accusations.
Exactly. It's the bedrock. An accusation, even a serious-sounding one like pro quioco, doesn't magically become proof in a courtroom.
And this wasn't just like one random judge's opinion, right? Plaintiff's counsel said there was an avalanche of decisions from New York courts all saying the same thing about these RICO allegations.
Oh, absolutely. And avalanche is a good word for it. The courts across New York have been incredibly consistent, basically slamming the door shut on attempts to drag these unsubstantiated RICO claims into unrelated personal injury trials.
Why is that? What's the reasoning?
Well, the courts see them as collateral matters, meaning they're off to the side, not directly relevant to the case at hand, like is the defendant liable for the plaintiff's injuries? They see it mostly as a distraction.
Okay.
Take the McGill v. Whitney Museum case. The judge there was really explicit. They said bringing in these unproven allegations would cause far more prejudice, unfairly swaying the jury than providing any actual insight.
So it muddies the waters.
Exactly. It muddies the waters. The judge said it would just distract the jury from the main event liability and damages. And crucially, they pointed out that just because someone filed a lawsuit doesn't prove anything. It has very little what lawyers call probative value in this trial. It doesn't help prove or disprove the actual facts of the McLaurin case.
Okay, that makes sense. So if the courts keep blocking these allegations from even being mentioned in trial, how does that affect the defendant's whole argument about a conflict of interest for the lawyers? If it's not evidence, How can it create a conflict?
Well, it pretty much guts the argument, right? The plaintiff's lawyers stated clearly they had done no wrongdoing. And the legal bar for kicking a lawyer off a case is really, really high.
It should be, presumably.
It should be. There's a case, matter of Lovich v. Lovich, that says basically you need actual prejudice or a substantial risk thereof. Just the appearance of impropriety isn't enough. You can't disqualify a lawyer based solely on unproven allegations floating around somewhere else, especially allegations the courts won't even let you talk about in court.
Right.
So that defense argument that going to trial would create further evidence for that RICO case. Plaintiff's counsel pointed out, well, there was no evidence in the first place to build on.
A good point.
And that brings us back to that demand for an allocution from the plaintiff, which counsel called ludicrous.
Yeah, what was that about?
They basically argued, look, that's not how our system works. Everyone's innocent until proven guilty. Mere allegations, unproven claims, they don't have any legal weight, they don't require anyone to do anything, certainly not confess to a non-existent conflict.
It's a core principle. And wasn't there something specific about the plaintiff herself, Chantel McLaurin, that made the conflict claim even weaker?
Yes, absolutely. This really highlighted how thin the defendant's argument was. Get this. Chantel McLaurin, the person suing in this case, she is not even a named defendant in that big civil RICO complaint.
Really? She's not even named?
Nope. She's apparently just described in it somehow. And this isn't unique. Other courts have looked at similar situations like in the Penal and Cifuentes cases mentioned in the filings and noted the plaintiffs there weren't named defendants in the RICO suits either. There was no proof they did anything wrong.
Okay, so if the plaintiff herself isn't even formally accused in the RICO case, then how serious can this supposed conflict really be for her lawyers? Especially when the allegations against the firm are themselves deemed inadmissible in this trial. It just doesn't add up.
Right. So that first big maneuver, disqualifying the lawyers, looks like it hit a brick wall of legal precedent.
Pretty much, yeah. But the defendant wasn't done. Still, at the 11th hour, they tried another major tactic, moving the entire trial out of the county. They wanted to shift it from Kings County Supreme Court, that's Brooklyn, all the way to Nassau County Supreme Court on Long Island. What was the reasoning this time?
Okay, so this one was based on the fact that one of the plaintiff's attorneys, Frank Melendez, is married to a judge in Kings County, the Honorable Consuelo Melendez.
Okay.
So the defense basically argued that because of this marriage, any judge hearing the case in Kings County would automatically be biased or at least appear biased.
Wait, any judge in the whole county? That sounds broad.
Extremely broad.
Yeah.
And legally very problematic.
I imagine you can't just move a trial because you don't like the county or have some vague feeling. What's the actual legal standard for changing venue like that?
It's incredibly high, as it should be. You can't just forum shop easily. Under the New York rules, the CPLR 510-2, you need actual facts which demonstrate a strong possibility that an impartial trial cannot be obtained.
Strong possibility based on facts.
Yes. And the courts, like in that Krupke case we mentioned earlier, are very clear. Mere belief, suspicion, or feeling are not sufficient grounds.
Yeah.
You need concrete proof of likely bias, not just a what if.
Okay, so belief and suspicion aren't enough. No wonder the plaintiff's counsel called this claim completely frivolous and ludicrous. What were their specific counter-arguments?
They laid out some very clear, practical reasons. First, Judge Melendez, the attorney's wife, was in no way assigned to the subject action. She had nothing to do with this specific case.
Okay, that seems important.
Critically important. And more than that, she couldn't be assigned to it. Why? Because she is a judge in the medical malpractice part, this McLaurin case. It's not medical malpractice at all. So zero chance of her presiding.
So the potential conflict they were worried about literally couldn't happen in this case.
Correct. And on top of that, the defendant couldn't point to any rule whatsoever that supported their preposterous notion that simply being married to a judge in the county created bias for all judges in the county. You need actual legal support for these motions.
Right. You can't just invent a rule.
Exactly. And that Krupke case is relevant again here. In Krupke, the court refused to move a trial, even though the plaintiff worked in the same courthouse as a family court employee. The connection needs to be much more direct and demonstrably prejudicial than just, existing in the same large county court system.
That really puts it in perspective. What if this kind of argument was allowed, though? What would the consequences be? It seems like it could cause chaos.
Oh, it would be incredibly disruptive and fundamentally unfair. Plaintiff's counsel pointed this out directly, the dangerous precedent it would set. They argued, by defendant's logic, your affirmant, meaning the lawyer writing the document, would never be permitted to try a case in Kings County Supreme Court simply because your affirmant's spouse is a judge in the courthouse.
Yeah, that would bar huge numbers of lawyers.
It would effectively sideline attorneys just because their spouse is a judge, even if that judge has zero connection to their case. That's not only impractical in a place like New York City with many interconnected legal professionals, but it undermines the principle that we trust judges to be impartial unless there's a real specific reason to doubt it in a particular case. The whole system relies on that trust, not on avoiding any possible remote connection.
So these were two pretty bold last-minute attempts to derail the trial, and both seem to have run up against some solid legal walls.
Very solid walls, built on precedent and procedure.
Okay, so let's step back. We've gone deep into these filings. What does this whole episode mean for you, the listener? Whether you're, involved in high-stakes negotiations yourself or just trying to understand complex systems, what are the big takeaways here?
Well, I think there are a few really powerful insights. First, and maybe most importantly, it just hammers home that critical difference between allegations and evidence.
Right. We kept coming back to that.
Yeah. It's not just legal jargon. It's a fundamental principle for fairness. In your own life, when you hear a claim, maybe in the news, maybe at work, maybe just gossip, it's crucial to ask, okay, is that just an accusation or is there actual verifiable proof? The courts are meticulous about this to keep trials focused and fair, and honestly, it's a great habit for thinking critically about anything.
That's a really useful point. What else?
Second, you really see the power and the importance of legal precedent. That avalanche of decisions blocking the IIO allegations, that wasn't an accident. It shows how past rulings create a kind of predictability and stability.
Like guardrails for the system.
Exactly. Guardrails. When courts consistently rule the same way, it discourages these kinds of, frankly, long-shot tactical maneuvers. It builds confidence that the rules aren't just going to change suddenly. It protects against gamesmanship.
Okay, so allegation versus evidence and the power of precedent. Anything else?
Yeah. I think finally, it really highlights the court's role as more than just a referee deciding who wins. The court is actively managing the process, protecting its own integrity.
Gatekeeping, almost.
Gatekeeping is a good word. You see the court here pushing back against what the plaintiff's lawyers called desperate last-ditch attempts to dodge liability. It's a reminder that any fair system needs these checks and balances, active oversight, to keep things on track and prevent them from getting bogged down by misdirection or desperation.
It really paints a picture of the legal system as this dynamic process, not just a set of static rules. It's about applying those rules, defending against manipulation, ensuring fairness in real time. This deep dive definitely shows that justice isn't only about the final outcome, but about that whole rigorous process, the rules, the vigilance needed to make it work. It really makes you wonder, doesn't it? How often are these kinds of tactical games played in legal battles, and how effective are the systems usually at seeing through them?
It's a constant tension.
So, thinking about all this, what stands out to you the most about how our legal system tries to balance that right to make accusations, which is important, with the absolute necessity for real, hard proof before consequences follow? We hope walking away from this deep dive leaves you not just, informed about the specific case, but maybe with a sharper eye for that intricate dance between claims and evidence wherever you encounter it.